Today's Imprint Weekly podcast is brought to you by Accenture. Change is afoot in child welfare. Change that means agencies focus on results for children and keep far more of them safe at home with their own families. Accenture's child welfare team is leading the way in the effort to ensure technology does its part in that success story. Accenture offers cutting-edge case management tools that ensure agencies can see insights that drive decision-making and caseworkers have information they need at their fingertips. Together, these tools help agencies stay laser-focused, reinventing child welfare into a source of strength for families when they need it. For more information, visit www.accenture.com/childwelfare.
Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of the Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at @theimprintnews. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. On this week's podcast, we're going to flip the normal order of things around a little bit and have our guest on first. That's Olivia Allen of the Children's Funding Project. She's going to join us to break down what happened on election night for youth and family funding measures, and we talk a little bit more about local children's funds in general. Then we are going to break down the oral arguments in Brackeen v. Haaland, the major Supreme Court case heard last week, in which the future of the Indian Child Welfare Act, better known as ICWA, hangs in the balance. We have been focused on ICWA and the Brackeen case in the lead up to the arguments on this podcast for 4 weeks now. So, of course, we had to discuss what went down at the actual arguments. I will also post our coverage of the arguments and our reporter Nancy Marie Spears' really terrific piece on sort of the lively protests and demonstrations outside of the court on the day of the argument. So let's get right to our conversation now with Olivia Allen about youth funding on the ballot last week. We are joined today by Olivia Allen, Strategy Director at the Children's Funding Project, which works with communities around the country to help raise the investment and opportunities for children and youth. To discuss, a few things, but in particular, we'll start with what got passed and didn't, perhaps, in ballot measures around the country for kids. So, Olivia, thanks for jumping on with us on the Imprint Weekly Podcast.
Yeah, thanks for having me.
Podcast rules, they got to know a little bit about you before we get into some weighty subjects. So I'm going to ask you to give me at least one of your favorites. Movie, TV show, book, musical group, or sports team. You can give me more than one, but you got to give me one. Olivia, what do you got?
Okay. I was just saying this last night. Silicon Valley has bumped back up to one of my favorites because it feels like what's actually going on over there right now with all the Twitter chaos. So I've definitely been opening that and rewatching that right now.
They must have one of the most unprecedented random upticks in rewatch of any show that's ever happened, right? No?
Absolutely.
Like when some famous song from the 70s or 80s ends up in some like in Stranger Things when that Kate Bush song came in, and then all of a sudden I'm sure Silicon Valley is having its moment right now with that. Yeah, for sure.
It must be. It feels too similar and too relatable, especially if you're somebody in Silicon Valley right now.
Oh, yeah. So in addition to the many contested elections that I'm sure our listeners are following here, as always, on the ballot were some measures and initiatives, some of them on very potent, controversial issues, access to abortion, legalization of marijuana, things like that. Also, every year, there's at least a few of these ballot measures, either on the state or local level, that really drill down to, more support for youth and their families. So let's whip through, 6 measures that you guys had your eye on at Children's Funding Project. Before we start, though, did the project? I've never been clear on this. Do you guys have a hand in actually, organizing and campaigning for these measures?
Yeah, it varies dramatically. So we, at the highest level of intensity, we work. I'm on the phone at least every month, and then closer to election day every week with campaign teams on the ground, helping to get organized from what are we even going to propose, 2 years out from election day, to helping them select campaign vendors and helping them with their campaign budgets, to then just being moral support and cheerleaders on election day. And then there's other measures that maybe our 501c4 pooled political fund will support, and we'll have some kind of contact off and on with them about that, but that we won't have a direct hand on the ground in organizing or decision making. So it varies, and I can
Yeah.
speak to that for each of these.
But fair to say that you guys are a kind of a logistical and capacity type of partner. Like, you need people on the ground. You're not going to do it yourselves.
Exactly. We
Yeah,
would never do it on the ground. And that's
yeah,
definitely a core value for us too. Of we're here to build capacity and support for folks who want to take advantage of the direct democracy opportunity provided by
mhm.
ballot measures. But it has to be a decision of the community on the ground. It's never going to be us pushing it.
Got it. Okay, so let's go through these. I'm just going to call out what it is, and then Olivia will take you through sort of what was on the table with each one of these and how it went. So let's start with the big boy of this group for the year is New Mexico Constitutional Amendment 1. I think $150 million a year was on the table for early childhood, and maybe some more, I think, also for just education. So go with it, Olivia. What was this about and what happened?
Yeah, this is a really exciting one. It is pretty wonky. So it's a constitutional amendment that takes more out of what's called the Land Grant Permanent Fund than usual. So if you think of the Land Grant Permanent Fund in New Mexico as being this big fund that oil and gas usage of public lands in New Mexico, the revenue from that goes into a big fund that's about $26 billion. That's about the value right now. And the state gets to decide, okay, how much of that are we going to take out each year and actually spend? So this constitutional amendment increased the amount that they take out each year from 5% of the fund to 6.25% of the fund, which folks decided was fiscally responsible. And that allows for $150 million to go to early childhood education annually and another $100 million to go to K-12 education. And this is a 10-year or so labor of love for the coalitions on the ground there. They have been working on this since, they've been 49th or 50th in child well-being in kind of the rankings we look at since 2012. And that really kicked off this decade-long effort to change that for New Mexico. So this is a really exciting step forward for them.
I'm assuming from your tone there that it did get approved.
Yes, I'm so sorry. And it got
That's
approved
okay.
by 70%,
Oh,
which
wow.
is
Yeah.
a
So
pretty
that cuts across
resounding
parties.
score.
That's
Yes.
parties and people in the middle all kind of agreeing we got to do better on this. And they do, man. They really get hit with the headlines every time, like, the kids count report comes out dead last. And I don't feel like people in the state really feel that way about their efforts, right? Or their intentions. It's just a
No.
resource problem on some level.
It's definitely a resource problem. They already have an early education and care department at the state level. They have more organization and coordination. They're working on fiscal mapping and cost modeling. They're working on all these levers that are important policy levers to pull, but it's an under-resourced problem there. I would say they're definitely not in the bottom tier of sophistication in terms of state coordination around this stuff. So
Mhm.
that really indicates that it is a money problem.
All right. Next up, San Francisco, California, Measure DD. What's this one about?
Yes. Yeah, and I don't believe the results are final for this yet, but I think it's pretty fair to call that this lost by a good chunk, 57 to 43%. This is a really interesting one. This would have been $70 million for universal pre-K in South San Francisco, which is its own city. And this was kind of a unique funding mechanism. They were going to add a parcel tax, which most people won't know what that is because it's sort of unique to California, but it's sort of like a property tax. It's a flat tax on pieces of property rather than on property value. And it was really aimed at commercial properties over 25,000 square feet. So it was aimed at a couple of the big commercial real estate owners in South San Francisco. And a ton of money was poured into the opposition to this measure because of the couple of companies it would have mainly affected. So we still have to do kind of a debrief with them on how they feel about what happened. But this is definitely, it was an experiment, what they were proposing. And it was a different group than we usually see organizing and coalescing around this. It was led by the DSA and a ton of labor unions. And so I'm unhappy to see this fail, but it was a bit more of an experiment.
And again, this would have provided, had it passed, and again, I guess we don't officially know which way it went,
Yeah.
universal pre-K for South San Francisco, which if you've been there, that's like it's where Candlestick Park used to be. It's kind of separate from the city you see in pictures. But what's the What is the sort of demographics around South San Francisco? Sort of a working class area of
Yeah.
the city, or the
Yeah, it's
metropolis.
definitely it's an area that is like, has a lot of the folks who have to work and play in San Francisco, but
Yeah,
can't quite live there. And I think what was really interesting about this measure was the acknowledgement that the challenge of getting childcare and pre-K in that area is an economic challenge. And they were proposing really progressively a requirement that providers, teachers for this make 2.5 times the minimum wage, acknowledging that it costs $20,000 a year to get pre-K in that area right now, which is not affordable for the vast majority of families there.
yeah.
So yeah, so it would have really been one of the more progressive measures in terms of wage equity, and so that's really disappointing to see not pass.
Next up, Jackson County, Missouri. It's called Question One. How this one shake out, and what's it about?
Yeah, this one passed 75% to 25%, which is super exciting and a resounding level of support. And a couple things are interesting about this one. So this was an already existing children's services fund. And in Missouri, there's state enabling legislation that allows localities to put on the ballot a children's services fund that provides mental and behavioral health supports primarily for children and youth from, teen parents all the way through late adolescence. And they've had a fund since 2016 when voters agreed to a 1/8 cent sales tax to fund this. And this measure doubled the tax revenue that will go to this from 1/8 of a cent to 1/4 of a cent, which is great because they were only meeting an estimated 40% of the need that they saw in the community with the existing funding. And it removes the requirement that they go back to the ballot to reauthorize again. So this was a big win for them. And I'll just sneak in that, knock on wood, we've never seen a fund reauthorization fail. So of the 49 children's funds in the country, any that's had to go back has passed, and many have had to go back multiple times. And usually the percentage of support goes up every time. So that tells me that communities, once they've established these, they
They
get
like
really
it.
attached.
Yeah.
Yeah.
But was that the stakes here? I mean, so if they won, which they did, it goes
Yeah.
up. But if they had lost, would it have not reauthorized it at all?
I think they would have had time to try and reauthorize again. I
Mhm.
believe I should check on that, but a lot of the times these funds will go earlier than they're required to go for their reauthorization period in case they fail, in case something else big is on the ballot, in case something
Got it.
weird happens. Yeah.
Yeah, which certainly can happen. Back to California. We're going back to California twice. Spoiler alert. Sacramento County, California, Measure L. I think this one had to do with marijuana tax. What is this one about?
Yeah, this one is really complicated. So hang with me on the wonkiness here, but I'll start by saying that they won by 60%, 60 to 39%. That's an unofficial result as of right now, but that's a pretty resounding yes. And this is also a labor of love. They had actually put this on something similar on the ballot in 2016 and 2020 and failed both of those times. So this is a big win for them, for the coalition they've built for SAC Kids First, which is a youth-led, youth-driven coalition that's really built up over this effort. But the wonky part here is that it is what is called a budget set aside. So the way they framed it is of the general fund, of the general budget amount that Sacramento has, they will set aside a portion of that that is equivalent to 40% of their cannabis business tax revenue. So it's not using the cannabis business tax revenue directly, but it's saying whatever that revenue is, we'll set aside an amount equivalent to 40% of that. And what that gets around is the challenge that has existed in California, where it's been going back and forth in the courts for at least 5 years now, of if you're going to impose a special tax in California, do you need a supermajority to pass it? And a budget set aside only requires 50% plus one. Whereas if they'd taken the cannabis business tax revenue directly, there was an open question about would that require a supermajority, so 67% of the vote. So
Oh,
that's a wonky California thing that has made it really challenging over there, as you can see from kind of the spread of the measures there this year.
so basically every year now, they're like, I'm assuming it's the past year tax revenue. They say, what's 40% of this? Okay, we have to put that in the budget for youth develop. It's a youth development program bucket, right? So that can be
Yeah,
out of school time. It could be mental health. It could be alternatives to incarceration. Like, is it that wide?
Yeah, it's wide. There's five key points that were in the bill. And so it was like after school and summer programs, youth workforce development, youth violence prevention and outreach, mental and behavioral health services. And then they also put in healthy development for ages 0 to 5 to keep it sort of cradle to career and encompassing of kind of the whole arc of childhood. But yeah, the drivers of this Stack Kids First, that coalition is a youth-led, youth-forward coalition. So that's reflected both in the actual policy and in the campaign itself.
Yeah. Before we go on, I'm curious for your thoughts on this. I was surprised to see that 5 states had legalization of marijuana on the ballot and only 2 approved. This was really moving in the direction of like most states that were putting it up were approving it. And why this relates to what we're talking about here is that obviously, as you can see with Sacramento and a lot of counties in California and places all around the country, the tax revenue drawn from the legalization process often somewhat gets routed into child and youth services. So I guess did that surprise you that more than half of the states that had it up, the voters put it down?
Yeah, we actually play a game in our office where we kind of try and rank we watch all of that because marijuana revenue is a really awesome, excellent source of revenue for youth development stuff specifically. It makes sense to voters that, if you're going to legalize marijuana, you're also going to want to build up a web of programs for youth and for kids that are alternatives to doing drugs after school, essentially. And that makes a lot of sense to voters. We weren't surprised because we had looked at the polling ahead of time, and the polling was not great in the states where it failed. And I think part of that is in Missouri, at least, a big chunk of it was the actual policy design. Weirdly, voters are in some states, it kind of comes down to the actual policy design, which that does surprise me in some ways because you think people would just kind of have a knee-jerk opinion one way or the other.
100%, I would have thought that. Yeah.
Yeah, but I think there's a trickle down of opinion on it from the policy design from kind of the grass tops folks. It really impacts whether grass tops folks like mayors, governors support it, which is what happened in Missouri. It lost grass tops elected leaders support because of the policy design itself. And that really impacts public opinion in some places.
It's that time of year where nonprofit journalism organizations are looking to maximize giving through the annual News Match campaign, and we are no exception. If you enjoy this podcast or the great work our reporters do at the Imprint and at Fostering Families Today, please consider making a donation. And if you do so this month or in December during News Match, your donation will get doubled. Fostering Media Connections is very lucky to have some terrific philanthropic supporters, advertisers, sponsors, subscribers, but we really cannot do it without donors like you who read our stuff, listen to our podcasts, and attend our online events. There are tons of really great nonprofit independent news outlets to support out there, and we hope you consider us one of them. To give today, it is easy. Visit imprintnews.org/donate. That's imprintnews.org/donate. All right, getting back to the ballot measures. Whatcom County, am I saying that right? In Washington.
Yes. Yeah, Whatcom County, Bellingham, Washington. This one is the reason I have my millennial emotional support Starbucks on the desk with me right now. And this one is a labor of love for us. We've been working with them for several years now, and it's come down to they have 7,500 votes left to count, and they're within 1,000 votes, and they're on the losing side of 1,000 votes right now. But we have all our fingers and toes crossed and are really hopeful on this one. And this would be $8.2 million, primarily for childcare and early childhood improvement, but also for stabilizing families experiencing housing instability and mental health challenges. And it's just in general, a healthy development fund is how they've framed it. And what's going on here is that the question itself was framed as a levy lid lift, which means that it would increase the property tax past the quote unquote lid or cap. And I think the framing of it as a levy lid lift, which is like how it was labeled on the ballot, is what's really bringing them down here as compared to the emergency fire services measure that's doing really well there, that was framed as just a property tax increase, not a levy lid lift. So my whole heart is in Whatcom right now, hoping on that one and those last 7,500 votes, and we'll have to wait and see what happens.
Is it fair to say that when it comes to having voters decide directly about, these types of things, increasing money through different tax mechanisms and things like that, the hardest lift is trying to convince homeowners that it's a good idea to raise property taxes or theoretically lift the ceiling on how much they could be taxed?
Yeah, that's a really good question. So we've actually done national polling on this, and I read polls in as many states and localities as I can get my hands on. And property taxes are definitely a lot lower in terms of support than the most popular taxes, which are, like we saw pass in Massachusetts, millionaire taxes, wealth taxes, corporate income taxes, digital advertising taxes, marijuana taxes. There's kind of these couple layers from high income earner wealth corporate taxes is the top layer. Then there's kind of the special excise taxes, or as some people call them, sin taxes in the middle that people support: sports betting, marijuana, alcohol, tobacco. And then on the bottom rung, it's sales and property tax. And what's frustrating about that is that in almost every state in the country, localities are limited to what tax mechanisms they're able to access. So you actually can't, in most states in this country, have a local special tax on wealth or on high income earners and things like that. And you're limited to property or sales tax. So property owners are asked for their tax dollars for a huge range of purposes and from a huge range of government entities. So it's definitely safe to say that in places that have more special tax ballot measures, which is mostly the West Coast, that those folks feel a greater sense of tax fatigue than folks who have more options available to them.
Last one on the list here, Monterey, California. We're back to California. The Safe, Affordable, Quality Child Care in Monterey County Act. Well named to make anybody really feel bad if they voted against that. I would imagine.
I know. And
what happened here?
This speaks to the point you just made, because like the South San Francisco tax, it is a parcel tax, which is essentially, a form of the property tax that is not based on property value. And this one looks like it's losing handily. Again, it's not official. Would have generated $5.5 million for safe, quality, affordable childcare. And I think they faced a couple challenges there. They face a really complicated set of demographics there of there's incredible wealth in Monterey County, and there's also incredible poverty in Monterey County. So it's a really challenging demographic to message to. I think that is the one where I'm the most curious about what happened, why there's the biggest spread right now between support. And yeah, that's a lot of points lost from their initial polling. And sometimes that happens when an opposition group puts a lot of money into a measure, which can happen and didn't happen in some of the places you saw win this year. So yeah, it's a negative one to end on, but it reinforces the point you just made, where parcel taxes specifically are not popular in California.
You mentioned when we're talking about Jackson County in Missouri that there was a children's fund there already. When these things, take root, they tend to be popular and then, hard to do away with. Can you talk a little bit about first just what a children's fund is and how they're traditionally, resourced, but then also why, I should just quick tangent here. I'll post a link to Children's Funding Project's website because they have some really awesome resources and great visualizations and stuff like that. And what jumps out when you look at the map of children's funding or children's funds is, why are they all in Florida and Missouri, right? I mean, there's
Yeah.
in other places, but a lot of the map is empty, and then those two are kind of bright yellow. So talk about what the mechanism is and sort of why those two states have such a concentration.
Yeah, absolutely. Voter approved children's funds is a name that we kind of made up to capture what we've seen happening in those states and some others. And all they are is dedicated tax revenue to a group of people who then administers that funding for children and youth in some capacity. So it's a little bit like a school board, right? You have a school board for K through 12. That school board gets its own taxes, its own property taxes usually, and then funds the school day. A voter approved children's fund is similar in that voters approve a certain amount of a tax to be levied and dedicated to what we call the other 80% of a 0 to 18-year-old's developmental time outside of K-12, all the other things that a kid needs. So usually this comes with some of the highest accountability of any government spending because it has an oversight and advisory board. It's required to report back to the local legislature. And it creates an infrastructure that I think we saw this borne out a lot during COVID that is really crucial to keeping these services knit together, coordinated, and up and running. In San Miguel County in Colorado, where they have an early childhood children's fund, they managed to keep all of their childcare providers open during COVID in this rural area, which, if you've been looking at the news, is not the case
Huge
in
problem.
other places in
Yeah.
the country. Yeah, because
Yeah.
that funding allows them to coordinate and reach out to all of the existing providers. There's nobody else who kind of sits over and organizes all of the providers in a certain area of children's services and coordinates and figures out the need and where do we need quality improvement, how do we provide training on trauma informed care to all of the after school providers in our area. So that's what a children's fund is. And the reason there are some concentrated areas of children's funds in some states is because some states have decided that, hey, this is a good idea. We're actually going to create enabling legislation to allow this to happen. So depending on what state you're in, your locality may or may not even have access to putting a special purpose tax on the ballot. In some places, any new tax has to go to the general fund, and that funding has to be decided every single year where it goes by the local legislature. So in some states like Florida, back in 1946, Pinellas County, Florida, a judge there decided they wanted to create a children's fund. And then a couple decades later, Florida decided, hey, that was actually a good idea, and other localities want to do that. We're going to create legislation that kind of dictates how are those created, how much money could they theoretically levy, who would have to be on the advisory board, and it kind of paves the way. Whereas when we're working in Whatcom County or in Kent County, Michigan, for example, that passed a fund in 2018, they have to kind of create from scratch. Well, what would our advisory board have to be? What tax mechanism could we use could we levy to fund this? What things would we support? So in places like Missouri and Florida, and actually Colorado has enabling legislation now, there's more of a blueprint laid out. It's been authorized by the state, and that makes it a lot easier. And we also believe that the desire for voter-proof children's funds is contagious, for lack of a better word. And in places where you have one, you start to see them pop up. So if you look at our map, you'll kind of see that in California and in Colorado and in some other states as well, that there are clusters of interest.
Last thing, and then I'll get you out of here. I mentioned your guys' resources on your website. You guys have some really cool stuff that people can go to kind of see, when it comes to the Rescue Plan Act, right? The last very large stimulus related to the COVID pandemic. What examples of what states or local counties are doing with that money for children and youth, if you want to understand kind of the total universe of money available. So again, I'll link to that for folks, but I'd say on just the macro level, how do you guys feel the rescue plan has impacted children and family kind of spending? Or would you say that the sort of broader narrative is that the money's been effectively utilized for this stuff, or there's a lot of money on the table and people really are, for whatever reason, not doing a great job maximizing it?
Yeah, unfortunately, I don't have a clear yes or no, black and white answer on that, because I think it's been a real proof point for us and for our organization that in places that have some infrastructure in place and have some bandwidth in place and have done a needs assessment of what do kids and families need in our area and have a children's cabinet, which is, kind of a coordinating board of people from all different sectors that impact kids, right? Those places have been able to effectively advocate for and use the ARPA funds. And then there's places where, the state legislature, like in Texas, has tied up the funds that were supposed to go to their schools and made those difficult to access, or where, there's no person or entity to really even receive the dollars or figure out which childcare providers need the childcare funds from the CARES Act and from the American Rescue Plan Act. So it's been a really mixed bag, and it's really reinforced, I think, for a lot of people how important the infrastructure is. Of you need somebody who knows the name and capacity of the providers in your area and where you have gaps already. You can't just walk into this, throw a bunch of money at it and say, use this somehow. So it's been a big proof point for us. And in a lot of places, we're excited that we feel like it's given the advocates who've been working to increase funding for children and youth services. It's given those folks a foothold, a toehold. It's started to socialize the idea of spending a bunch of money on this, and it's given people an opportunity to demonstrate the effectiveness of their organization in improving the lives of children and families in their community. So for those folks, it's really exciting, and it's also scary because it creates this cliff, right? If that funding is going to go away, but it's created some urgency, some much needed urgency for folks there of, okay, clearly we're using all this money effectively, and that money is going to go away. How are we going to replace that now that people have gotten used to the level and quality of services we're able to provide with that? So it's exciting for us in some places. It's been disappointing in other places, but a good proof point, and I think demonstrated to a lot of people how lacking we are in infrastructure for supports for children and families in this country right now.
Olivia Allen, Strategy Director at the Children's Funding Project. Thanks for jumping on with us on the Imprint Weekly Podcast.
Thanks so much, John.
All right, so me and Olivia Allen talked about ballot measures that pertain to children and youth funding. In addition to those measures we just discussed, let me go quickly through a few other state and local ballot initiatives that were up for a direct vote from the public last week and that have the potential to impact child welfare or youth justice, either in the near term or in the long term. You had 5 different states where voters were deciding on access to abortion. California, Michigan, and Vermont voters all went to the polls to decide whether or not there would be some guarantees of access to abortion. And in all 3 states, that was the choice of the majority of voters. Kentucky had a constitutional amendment on the ballot this year that would have barred the state's constitution from ever creating a right to abortion, sort of going the other way and restricting access at the state level, and that failed. The Montana initiative is a little more complicated. It was a bill that requires life-saving efforts to be administered for any born alive infant, with some pretty vague definitions on what exactly that means. But that one also appears to have failed. Legalization of marijuana has been on several state ballots over the recent years. I think 19 states right now in the country have legalized the use of marijuana, and there were 5 states that had voters decide on this in the 2022 election. They were Arkansas, Maryland, Missouri, North Dakota, and South Dakota. And as you heard myself and Olivia talking about in the conversation we just had, only 2 of those 5 passed recreational marijuana legalization. Those were Maryland and Arkansas. Missouri, North Dakota, and South Dakota all voted down the legalization of marijuana. Minimum wage. Research has indicated that rising minimum wages are associated with lower reports of child maltreatment. A minimum wage hike was on the ballot in 2 states this year. Nebraska proposed in a ballot initiative to go up from $9 to $15 an hour by the year 2026. In Nevada, the proposal was $9.50 up to $12 by the year 2024, and both of those increases in the minimum wage were approved by voters. In addition to that, a few local measures of note passed. Oakland voters decided to establish 13,000 new low rental units. The Los Angeles ballot included a proposal of a 4% tax on the sale or transfer of any property over $5 million. That was going to fund affordable housing and homelessness prevention. And as of the time we are recording this, it may be different by the time you hear this, they had not decided whether or not that proposition, I think it's called Proposition ULA, had been approved or not. And then in New York City, voters were deciding on whether or not to create an Office of Racial Equity and a complementary commission on racial equity, with a mandate for the city to produce a racial equity plan every 2 years. Now, this initiative was approved, and I definitely expect that the operation of the city's child welfare and juvenile justice operations, which are both under the same agency, the Administration on Children's Services, or ACS, will be quite a focal point for the Office of Racial Equity and the Commission on Racial Equity. Certainly there is a large contingency of activists and lawyers who are pushing the city and really the state of New York to address the very large racial disparities in who among parents is investigated for child abuse and neglect, and the involvement of children in the foster care system. All right, when we come back, we will break down the challenge to the Indian Child Welfare Act and some significant moments from the oral arguments in Brackeen v. Haaland.
Are you a professional in the field of child welfare, juvenile justice, or other family and youth services? Subscribe today to Youth Services Insider, the Imprint's exclusive section on all the insider news you need to stay in the know. Funding opportunities, major federal and state policy shifts, interviews with key leaders in the field. It's all available only for our Youth Services Insider subscribers. Sign up for a monthly or yearly subscription today by visiting imprintnews.org/subscribe. Our podcast listeners get 10% off their subscription by entering the promo code PODCAST10. That's imprintnews.org/subscribe and get 10% off your subscription by entering the promo code PODCAST10 today.
We have been talking about and writing about ICWA and specifically the Brackeen v. Haaland case for some time at the Imprint, and finally last week, 4 years after the case started, the Supreme Court took it on and heard oral arguments. For the readers out there, I'm going to include our coverage again from the day in the show notes, along with a link to our full collection of coverage on the Brackeen case going all the way back to October of 2018, when a district judge touched all this off, declaring ICWA unconstitutional. Now, for the podcast today, I thought we would play a series of clips from the oral arguments that I sort of thought embodied the primary ways in which the justices and the attorneys use this discussion. So we'll roll each of these clips in chronological order and briefly talk about each one. Then I'll share a few overall sort of takeaways from the whole oral arguments day. First up, I want to play Matthew McGill of Gibson Dunn's opening statement to the justices. McGill represents the plaintiffs in the case, so not Texas, but the families that are involved, the adoptive families. He was their first attorney to go, so this is pretty much the beginning of what would become a 3-hour discussion.
There are fewer than 2,000 Native American foster homes. That means each year, hundreds, if not thousands, of Indian children are placed in non-Indian foster homes, and sometimes there they bond with those families. Yet when those families try to adopt those children, ICWA rears its head for a second time, allowing tribes to play the proverbial ICWA trump card at the 11th hour. This is happening now for a second time to the Brackeens as they try to adopt YRJ, who is now 4.5 years old. For a second time, the Brackeens are asked to show good cause to overcome the placement preferences under a new regulatory standard that, in the agency's words, is narrow, limited, and not a best interests test. Not even YRJ's deep attachment to the Brackeens after being part of their family for 4 years is sufficient. For both that child and her family, this flouts the promise of equal justice under the law.
I thought that was an important clip to play because this conversation really gravitated pretty quickly towards questions of constitutionality and case law, but it started out with this sort of emotional appeal from McGill, making child welfare-based arguments for the case. He alludes to the capacity within foster care, the larger number of Native American children who are in foster care than the number of Native American approved foster homes. He's talking about best interests and attachment. These are child welfare concepts, not constitutional ones. McGill asserts in this that the good cause standard within ICWA has created a barrier in ICWA adoption cases that does not have the child's best interests at its core. And I think this comes up a bunch in both in these clips and throughout the oral arguments. So I'll explain it. Basically, ICWA, as it applies to adoption, sets out some placement preferences and then gives good cause standards for deviating from those placement preferences. So the placement preferences basically say you have to try and keep the child first with their own family and kin, if not, then with a member of a tribe, and then if not that, any Indian family. And so these good cause standards basically create or specify different outs where a judge or a court could, deem that it was appropriate to place outside of those preferences. Some examples are if a youth in question who is in foster care or is living with a foster parent or somebody and voices their desire to stay with them, or if a biological parent wants to come to court and say that they have a particular preference, or if there's a sibling attachment or a sibling connection in play. Those are all things specified in the good cause standards of ICWA, under which, the court can decide to deviate. So we'll come back to all of this in a minute, because there's another clip that kind of relates to this. McGill also here is focusing on a child that is not actually part of this case. You heard him refer to YRJ. That is the sister of a child that is involved in this Brackeen case. And this is significant because it comes off as kind of an early salvo at trying to get the judges to see some very clear standing in this case. Because for the children that are actually involved in this case, all of their permanency has been settled. 2 of them ended up becoming children of the adoptive couples in the case, and the other one is an adopted child of his grandmother. All right, second clip here, and this one gets to a topic that came up a lot in the arguments, and that is the issue of plenary powers, which came up, I think, more than any other issue on Wednesday. The question of whether there is a limit to the power that Congress has to regulate tribes and tribal relations. So attorneys for the plaintiffs, McGill here is speaking, sought to press a limited view of plenary powers in this area, and a number of justices of varying ideological lean kind of probed those limits with McGill and with other attorneys. So this clip is Justice Sonia Sotomayor engaging McGill on the subject of plenary powers.
So what do you do with that line of cases like the Act of 1888, setting the evidentiary standard for proving a marriage in cases involving an Indian woman and a white man? That wasn't limited territorially. That set an evidentiary standard. Or the Trade and Intercourse Act of 1834 set burdens of proof in all trials, whether on reservations or outside of reservations, about property rights between Indians and non-Indians. The Act of 1799, state courts must take proper bail when federal officers detain offenders who trespassed into Indian territory. So that one arguably had something to do with that, but there's a legion of cases, as Justice Barrett alluded to, where Congress has gone off of Indian lands, had nothing to do with sovereignty, had nothing to do with trade or commerce, but with intercourse, with the relationship with Indians, whether on or off reservations.
Well, Your Honor, I guess I would have 2 parts to my response. The first is that the Constitution confers an authority to regulate commerce, and that power, as understood as Justice Thomas's separate opinion in adoptive couple, I think well
But that was
elaborates.
a separate opinion. We've described the power as more plenary than that.
Well, I think this is just the fundamental portion of my submission, and I respect the fact that we might not agree on this, but that there is a commerce power that allows the government to regulate commerce wherever it happens within the United States. And then there is, in addition to that, a plenary power that allows the government, the federal government, to regulate the tribes. And that arises from the federal government's role as the subjugating sovereign of the tribes, and its role as now under CAGMA, the protector of those tribes. But that power is not unlimited.
All right, so what you just heard was largely indicative of the various back and forths on plenary powers that happened throughout the course of these 3 hours. Justices really wanted to know what line should be drawn, if any. At one point, Justice Amy Coney Barrett asked, I think it was McGill, whether or not he would essentially set aside a large swath of Indian law cases from the Supreme Court's past and really ask them to draw a line that would probably put more than just the Indian Child Welfare Act into jeopardy and make a lot of things, back on the table for appeal and overturning. This next clip comes in an exchange between McGill and Justice Neil Gorsuch, who is widely seen as having the most knowledge on Indian law on the court and who has sided with tribes on some pretty significant cases before in his judicial history, most notably and recently with the McGirt v. Oklahoma case in 2020. So here, Gorsuch, at the end of a line of questioning that really was mostly about constitutional issues and a little bit about standing, confronts McGill with something he seems to see as odd, which is the argument that states are injured by ICWA in the face of very little evidence that states think so. So have a listen on that.
Is there some irony in your position that you're here to vindicate states' rights? We have 23 states who've lined up on the other side. We've never had a state court, near as I can tell, in the 40-some years since ICWA was adopted, complaining about this arrangement.
I don't understand that to be correct, Your Honor. I think there are state courts that have recognized that ICWA has it far exceeds what Congress's.
Have state courts held that this is unconstitutional?
There's the cases that held that it under what was known as the existing Indian family doctrine, that said that it would be unconstitutional as applied to a child who had no connection to a tribe.
Fair, but I'm not aware of anybody holding ICWA facially unconstitutional in the manner that you're asking us to do.
No, I would concede that no state court has
gone anywhere
done that.
Yeah, okay, thank you.
Right, so as Gorsuch notes in his comments here, there are 23 states that filed an amicus brief jointly in support of the Indian child welfare in this case. 2 states filed in support of Texas, Oklahoma, and Ohio. And it's sort of well known, honestly, in Texas that this was a challenge to ICWA that was brought by the Attorney General's office. They were the ones who sought this fight, and that the state's actual child welfare agency really has no beef with ICWA. Also worth noting that there were actually 3 states that started this challenge way back in 2018, Texas, Louisiana, and Indiana. And Louisiana and Indiana are nowhere to be seen. They are no longer plaintiffs on any of this, and they didn't even file briefs to support Texas at the end of the day. And then in addition to all that, Gorsuch is pointing out and asking McGill to respond to the fact that while challenges on the federal circuit about the Indian Child Welfare Act have become more frequent, Brackeen was the 3rd case to actually reach the Supreme Court, but there's certainly more action in the lower courts. No state court, he pointed out, has ever ruled the Indian Child Welfare Act to be unconstitutional or really come at it like that. This next clip is actually kind of a 3-parter, but we're going to piece it together and play them all back to back. And this harkens back to this issue from the first clip of the good cause standards for going outside of the placement preferences in ICWA. So first, what you're going to hear is Chief Justice John Roberts lay out a hypothetical situation where a non-Indian couple would, absent ICWA's placement preferences in his mind, clearly be the candidate that a court chose to go with in finding permanency for a child. So he returned to this hypothetical and this whole question of good cause standards a few times as to whether or not the good cause standards jeopardize the application of the so-called best interest standard in child welfare, or at least if he was probing the lawyers to see if they thought the good cause standard guaranteed that a child's best interest could be taken into account. So you'll hear from him, and then you will hear from Attorney McGill discussing why he feels that the good cause standards do not line up with best interest. And then you will hear from Ian Gershengorn, who represented the tribes in this case, arguing that this whole test of good cause against best interest actually kind of defies, in a way, the key original point of the authors of the Indian Child Welfare Act. So give a listen to all 3 of those.
Let's say there's a 6-month-old baby that had been born to an Indian couple, and the Indian couple, for whatever reason, is no longer there. And there are also no extended family members in the tribe. A non-Indian couple comes forward and says, we would like to adopt the 6-month-old baby, and they check all the boxes of their best interest of the child. In other words, in normal circumstances, this would be a perfect placement for the child. But non-family members of the tribe say that no, they think it would be better for the child to be raised with the tribe on the reservation. Does that priority trump the other best interests finding? To what extent is the best interests of the child, or the same considerations that are taken into account under the best interests of the child, incorporated in the good cause showing that could be made under ICWA?
I would say that they are not, Your Honor. I mean, the good cause standard is a holistic standard that takes all of the child's circumstances and needs into account. What the good cause standard does is sharply limit that under the 2016 rule to enumerated factors. In the 2013, when the adoptive couple case was before this court, the government described the good cause standard as a safety valve. That's footnote 2 of its brief. It is no longer a safety valve. The Interior Department has promulgated these regulations with the specific purpose of making it limited, narrow, and in its own words, not a best interest test. So it differs very much from what would be the traditional best interest test.
Do you think that ICWA incorporates the familiar best interests of the child inquiry that are applied in family courts throughout the country?
So I think I'd have to say the answer to that is no. What ICWA does is modify that because Congress made the judgment that the best interest standard was being implied in a way that resulted in unwarranted removals. What Congress did was create a system it thought was in the best interests of the child, but not by adopting the, quote, state best interests of the child standard, because it found that that was being applied in a discriminatory way. Now, so Your Honor, there's been a lot of back and forth about good cause, and it seems like good cause is important in the statute. I will say candidly, having looked at the cases, there are the state courts are in a little bit of disarray as to whether the preferences are sort of binding, whether there's a straight free-floating best interest standard that sort of that works through good cause, or whether, as I think is probably the way Congress intended it, that there's the placements are the default setting and good cause provides a way to rebut the presumption. Now, Interior has explained how good cause works. It involves, you can take into account the decisions of the views of the parents, the views of the child if the child is old enough to express them. You can take into account sibling attachment. You can take into account bonding with foster parents as long as it was not done illegally through ICWA. The thing you cannot take into account is socioeconomic status. So what the Casey brief and others say, and what the reason why medical professionals are here, states are here, family rights advocates are here, is because ICWA is the gold standard. It adopts those evidence-based presumptions and allows for flexibility to protect the best interests of the child.
So to sum up all of these different, pieces that you just heard, which, by the way, they did not come one after another. I sort of, Justice Roberts brought this up a number of times. So this is sort of a coherent piecing together of both sides' answers to his questions. To sum it up, I mean, Chief Justice Roberts clearly articulated some concern here about whether or not these good cause standards are sufficient enough to ensure that while ICWA's got certain provisions aimed at preserving tribes' standing and right to intervene in child welfare cases, that these good cause standards are enough of an out when it's necessary on a case-by-case basis to find different avenues for placement for kids. So McGill, arguing for the plaintiffs, is saying, no, it does not. And in fact, he's going to back to case law and saying that there was a 2013 case over ICWA. At that time, he was suggesting that perhaps the good cause standards were, in fact, a safety valve enough for this, but is arguing that since that case, which was in 2013, the Bureau of Indian Affairs has sharpened the definition of good standards in a way where it is too limiting in his view and his client's view, and creates significant barriers for the appropriate placement in their minds of a child. And then what Gershengorn's point is to say, you are examining good cause standards against this best interest concept, and the best interest concept is not something that was just created yesterday in child welfare. What Gershengorn is arguing here is that best interests have been around, and one of the things that prompted the authors of the Indian Child Welfare Act to act and write the law was that the best interest standards were not being applied in a just way to ensure families were kept together in Indian country at the time or in the Native American community. And Gershengorn points out a very specific thing that is kind of an elephant in the room when you're talking about all this, which is socioeconomic status. He points out that the good cause standards that would allow a court to deviate from the placement preferences here in ICWA can include, is the sibling of the child living with the the former foster parents, now adoptive parents, does the mom or the dad or both want the foster parents to adopt? Those are things that the good cause standards can consider. What it can't consider is poverty. Is the relative who is seeking custody or the person who is a member of the child's tribe, being viewed as not qualified or less qualified than a foster parent or somebody else because of their economic status? The good cause standards do not allow a court to assess that as something that would go against a family. Okay, last clip here, and this one is an exchange between Justice Amy Coney Barrett and Ian Gershengorn that was pretty intriguing on a few fronts for me. So at issue here is the active efforts provision of the Indian Child Welfare Act, which basically compels, child welfare systems to make a heightened level of efforts compared to other child welfare cases where the standard is reasonable efforts. So they have to make active efforts to prevent the need for foster care, to prevent the removal of ICWA covered children into foster care. And then anytime that the termination of a parent's rights is on the table in an ICWA case, they need to be able to provide clear and convincing evidence that active efforts were made to prevent the need for that termination. And Barrett seems to be probing on the issue of anti-commandeering and the anti-commandeering doctrine, the idea kind of advanced most in recent case law, really dating back to the 90s, that states should not be made to carry out federal law, referring to this part of the 10th Amendment. This is the sort of source for the anti-commandeering doctrine. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. So Barrett is posing to Gershengorn whether Texas, objecting to ICWA's requirements around active efforts, would be able to simply exclude Native American children, or at least the ones covered by ICWA, as essentially a compromise here, right? Could they walk away from handling those cases? Or going further, could Texas just not operate a foster care system because they disagreed with it? So give a listen.
One argument that the government makes is this isn't commandeering because you can walk away. You can decide not to do this. Would your client have any objection then if the state of Texas, General Stone said, our substantive law requires us to undertake efforts to place children in foster care in these circumstances, and it would be unmanageable for us to discern when a child is Indian or a member of a tribe or not? Let's imagine Texas says, okay, we want to walk away. We don't want to engage in these active efforts, so we're just going to get out of the business. And if we can discern that a child is a member of a tribe, our agencies will not be involved in placing the children in foster care.
So, Your Honor, I think that would be a disaster on the ground.
But would it be legal for Texas to do that? Would there be an equal protection challenge that someone could bring against Texas for treating Indian children differently when it comes to foster placement? You're saying that there would be political consequences or practical consequences to Texas walking away from foster care, and I agree. Yeah. And General Stone made that point.
And I think it would be hard for me to argue, Your Honor. I'm sorry to cut you off. Finish your question.
Oh, no, I was just going to say, but what I'm asking is if we're thinking about whether Texas has a legal choice, there might be practical considerations. I guess I'm trying to figure out, is this really voluntary?
So I think I would have to say, Your Honor, given that there were for the first 150 some odd years of our country, there was no child care system at all, that it would be hard for me to say that Texas is constitutionally required to have one. But if
they have one, could they cut Indian children out of it, is my question. Because they don't have to obey ICWA with respect to...
I think that would raise serious equal protection problems.
So they don't have a choice then?
Well, they have a choice whether to participate in the proceedings at all. They may or what they may not be able to do is say, I'm doing it only for non-Indian children.
Participate in proceedings, in foster care?
Correct.
In a foster care system?
Correct. I don't think there's any constitutional requirement they have a foster care system.
But if they have a foster care system, they couldn't say, because of what ICWA requires us to undertake in these active efforts, and they complain about the record keeping, we just want none of that, so we're going to walk away from that. We're not going to let the federal government impose those obligations on us.
So I think that's right, but I have to say, of all the answers I've given today, that's the one I'm least confident.
Thank you.
All right, so for starters, it is amusing that Barrett is throwing this out there a bit tongue-in-cheek. using the notion of a state doing away with foster care as an absurdity with which to enforce the idea that indeed ICWA is making the state carry out and enforce federal law, because there's a fairly significant movement afoot in America that I'm not entirely sure Justice Barrett's aware of that is pushing to do just that, to get states to abolish true child welfare systems as we know them. But more salient to the case at hand, Barrett was the only one that I can recall bringing up active efforts. I'd say 95% of the oral arguments was spent either discussing constitutional precedent or the portions of ICWA that pertain to adoptions, really the last step in the process with ICWA when it comes to the public side, right? There is keeping kids out of foster care, there's how they're treated in foster care, where they're in foster care, all coming before any decision around terminating a parent's rights or moving a child to adoption. Now, Barrett and Justice Ketanji Brown Jackson were the ones most interested on the bench during the oral arguments in discussing anti-commandeering in general. Jackson all but said she rejected the idea of applying this as a relatively new concept in jurisprudence to a decades-old law. I would say I did not get the same vibe from Barrett, whose questions seemed more an invitation to talk her out of seeing some or all of ICWA as commandeering to states. So a few final thoughts, having covered the oral arguments and digested quite a bit of conversation about them afterwards. And I'm going to start with the standard caveat with Supreme Court cases that how justices act and what they ask about in the oral arguments or talk about is not entirely indicative of what's to come here. There seemed to be little interest in the equal protection questions around the Indian Child Welfare Act, this question of whether or not, this law is a race-based law or a political one. After hearing the arguments, I'd be surprised if a majority of the court was of a mind to do ICWA in on that level. You definitely got a sense from some of the conservative judges that the third placement preference for adopted children, which can be any Indian family, not just ones from the child's tribe, that was not in line with the idea of honoring, the federal government's unilateral treaty or arrangement with a specific tribe. But that's a pretty tiny sliver of the law that honestly neither side proffered sort of any evidence that it's been used in such a way to have been appealed before in any case law. So it's this pretty small part of a piece of ICWA, and as far as anybody could unearth for this case, has barely been used. So set aside that for now. I would also set aside the idea that 5 justices in this case are going to agree that the plaintiffs lack standing to bring this case, although I have to say that to me it seems very legitimate that they would perhaps lack standing when you consider one of the more recent cases that the court heard on child welfare, which is Camreta versus Green. This is a while back in the 2000s. This case was about whether a child welfare agency, I believe it was Oregon's, or police need to obtain parental consent or a court order to interview a kid at school about potential abuse or neglect. Now, the court ruled in that case that the case had become, quote, moot because the child has grown up and moved across the country and so will never again be subject to the Oregon in-school interviewing practices whose constitutionality is at issue, end quote. That is true enough, but the girl, you could argue, might have been continuously traumatized by that experience of being interrogated at school. That's possible. And certainly, while she would never be subjected to it again, other kids certainly would if it continued to be a policy. So compare that to the Brackeen case. The Brackeens and the other family involved in this, the Librettis have adopted and unquestionably are the official caregivers of the child at the center of this case. But that child's sister in the Brackeens situation, YRJ, has a case still in state court, but it's unclear to me how that matters in a way that the future children in Oregon to be interrogated in school did not when it came to Camreta v. Green. But again, there was little talk about standing, honestly, throughout these 3 hours. And in Camreta, that was a lot of what they talked about. I recall that kind of standing debate was a big focal point in one of the juvenile life without parole cases from the 2010s. I think it was Graham v. Florida as well. So seems to me like if standing was really going to be at issue, you would have seen a lot of different justices asking about it, particularly the ones that are kind of in the middle where people don't know kind of where they fall on things. And I just didn't really feel like you heard a lot about that from most of the justices. All right, so setting aside the equal protection aspect and the standing, if you were to take the premise that the things talked about the most in the oral arguments correlate to the things that the case could hinge on, I would say the following pieces seem to separate themselves. First is whether what is done by ICWA is a reasonable thing for Congress to regulate through its established plenary powers as it applies to the tribe, which everyone involved seems to have conceded, at least historically, has gone well past just simply commerce and trade. Everybody basically said, yes, that is true. Congress has legislated well past that. The court has upheld plenary powers well past just commerce and trade. Gorsuch pressed McGill on if, for example, healthcare or education services would be considered outside of the bounds of plenary power, and if so, since they aren't classically commerce, why draw a line at child custody or child welfare? Second thing, do justices, or at least 5 of them, believe that the requirements of ICWA, some or all of them, are a mandate not just of state governments, but of other entities as well? In this case, that would mean private agencies or people or courts that are involved in helping to facilitate a private adoption or custody arrangement for an ICWA-covered child at the behest of custodial parents or caregivers. This is perhaps why it is significant that Justice Barrett honed in on active efforts here as much as she did. It's the most clearly aimed provision, I think, at public state agencies and their actions as opposed to private ones. To quote the Bureau of Indian Affairs guidance on ICWA and the active efforts, it says that ICWA requires active efforts prior to foster care placement of or termination of parental rights to an Indian child, regardless of whether the agency is receiving federal funding. That first prong is really only applicable with state intervention. Active efforts was one of the provisions that a majority of the Fifth Circuit Court of Appeals, which is the last federal court to hear this case, found unconstitutional. They also found unconstitutional certain record-keeping requirements and the requirement for a qualified expert witness. We had an interview with Tara Raynon, who used to be a qualified expert witness. If you go to our podcast archive, you can listen to that to learn what their role is. And that also, the qualified expert witness, is a requirement that would really apply in a proceeding involving involuntary removals where a state child welfare system is going to be involved. So qualified expert witnesses, that did not come up once, I'm pretty sure. But after hearing arguments, it does seem like the aspects of ICWA most directly related to foster care removals or to the involuntary termination of parental rights, those will be the most at risk. They will draw the most vexing, I guess, for some of the justices. If you assume Justice Gorsuch is a proponent of upholding ICWA entirely or mostly, and that is not a given, you can be sure that Jackson, Sotomayor, and Justice Elena Kagan are not going to be limiting the law in any way. So that would theoretically be 4 justices willing to uphold ICWA. Justices Samuel Alito, and Clarence Thomas are pretty safe bets to seek some pretty significant encroachment on ICWA, if not deeming it completely unconstitutional. So that leaves Chief Justice Roberts, Justice Barrett, and Justice Kavanaugh. Barrett, we discussed, and I'd say her questioning makes me think that she sees merit to the idea that at least some of ICWA's provisions could be commandeering to states. Kavanaugh really was the only judge that did go to race and equal protection quite a bit in his questions. He said, and I quote, "On the equal protection issue, it will be important for us to figure out the scope and limits of Moncari." And he's referring there to Moncari v. Morton, which is a case from 1974, where the court upheld a hiring preference for Native Americans at the Bureau of Indian Affairs as being not racial or racially motivated, but in interest of tribal self-government. Kavanaugh asked a couple times about the third placement preference on adoption that we were talking about earlier, which allows for a preference for any Indian family, not ones that are members of the same tribe as a kid, and how that could be construed, Kavanaugh was asking, as to be in the interest of Indian tribal self-government and not just simply treating it as race. So if he's a vote for ICWA in part or whole being race-based, unlikely I think he'll be in a majority with that, but he did not tip his hand at all to me about the other constitutional questions, in my opinion, because he was focused on that as much as he had questions to ask. And then there is Chief Justice Roberts, who certainly seemed concerned about the idea that ICWA imposes a barrier on applying best interest standards, as states are wont to do in determining removals, adoptions, terminations of parental rights, etc. It's worth noting two things about that, by the way. First, best interest is certainly common but not uniformly defined across the country or anything. And second, in this YRJ case that falls outside of the Brackeen v. Haaland, the Brackeens prevailed on a test of whether the good cause exceptions in ICWA would allow for a differential placement off of the preferences. There was a sibling connection, obviously, between the child involved in the Brackeen case and YRJ, and the Brackeens prevailed. They're very likely going to have adopted YRJ by the time probably that this decision comes out. I am not a legal expert, so I'm not sure where to put Roberts' best interest concerns in terms of like an actual constitutional finding versus an emotional one. So like, say his view is that the good cause standards jeopardize doing what's best for kids, or they don't do enough to ensure that. That seems like a policy view. So there's certainly another side to that. I mean, it was argued pretty well by Gershengorn in this case. This is also playing out in the broader discussion about child welfare, too. I mean, there's not some 100% conventional wisdom that the use of best interest standards as commonly applied has produced, uniformly just and safe outcomes for kids. So how does one take that concern of Roberts and apply it to Congress's plenary power or to anti-commandeering? On the former one of those, I don't see it. I mean, you either view the entire issue of children in custody as being outside of Congress's domain and plenary powers, or you don't. And with anti-commandeering, one could think that Congress's prescriptions were right, as many do with ICWA, and still believe that they constitute commandeering. So I'm not sure in that regard it really matters whether you think it's a good or bad policy. It is or is not commandeering, depending on your interpretation as a jurist of that doctrine. In the case of Ketanji Brown Jackson, perhaps viewing it not as something to be decided on at all. Our guest last week, Kate Fort, cautioned at the end of our interview with her that when this decision comes down, be prepared to give people time to digest it, figure it out, because it may not be that simple. Don't read the first headline you see, either from the Imprint or from other periodicals, and then go running around with your head on fire. And I think she's probably right after hearing this. I did not come away from a 3-hour session here thinking there's going to be an entire striking down of ICWA or a full upholding of it. I could be wrong. This could be biased by how much these two things came up, but it sure felt to me like the most likely provisions to be struck down were the third adoption preference, other Indian families, and the active efforts provision. And I would throw qualified expert witnesses in there too. But as far as this case is concerned, this marks an end to court action. All that is left is for the justices to decide and form some sort of majority opinion. I would expect there might be some concurring opinions in addition to that and a dissent. They have until the end of June to do this, and I think it's a safe assumption that with a lot of questions on the table with this case, it will be one of the last cases that they put out an opinion on in this term. So I want to thank all of our amazing guests that have jumped on with us in the past month or so to help listeners out understanding the provisions of ICWA and the stakes of the case. That'd be Shannon Smith of ICWA Law Center, Tara Raynon from NICWA, Chrissy Ross-Nemo from Cherokee Nation, and Kate Fort from Michigan State University for joining us. And thank you guys for listening to all of this. And I guess we'll certainly be following up as this case comes to a conclusion at some point in the summer. That wraps up the episode for today. Thanks to Olivia Allen of the Children's Funding Project for joining us. The Imprint Weekly Podcast is a production of Fostering Media Connections, a California-based nonprofit that publishes the Imprint, Fostering Families Today, and operates the Youth Voice program. This podcast is produced and mixed by Christina Onjoko, with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you'd consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. and we would really appreciate if you would consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, it is super easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle @TheImprintNews and visit us on the web at imprintnews.org. You can always email us at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.